As you know, or for those of you who don't know, Kenya has a new constitution. And this new constitution, Katiba, inasema people are supposed to get freedom to access information about themselves. And the question is, with the internet and the opportunities it presents for access to information, what effect does that provision have? And what is it going to mean for us? In order to make us understand these issues much better, we have two ladies from Article 19 who are going to tell us about Data Protection Bill and Freedom of Information Bill, which are currently in the works. And we also hope that we hear from UNESCO on opportunities presented by these two bills, and basically this opening of the information in what opportunities this presents in the fields of education, science, in culture, and so on. So without much further ado, welcome Stephanie.
Good afternoon, everyone. Please look lively. You've just had coffee and tea, and I'll be bored here by myself. So, my name's Stephanie from Article 19. Like I said earlier, we work to defend freedom of expression and freedom of information. We get our name from the Universal Declaration of Human Rights. And we're based in Nairobi, which serves the East Africa general area. So freedom of information. I just wanted to start with a brief introduction of freedom of information. Some of you may not have interacted with what the thinking is about that. So freedom of information, basically in a nutshell, refers to information, your right to access information, public information held by the state and by public authorities. And some private bodies that perform public functions or are publicly funded, but not all private bodies. So that's freedom of information in a nutshell. There's a whole lot of thinking and principles and what we call jurisprudence around freedom of information, but that's for another presentation. So I guess the next question I need to answer for you is, why do we need a freedom of information bill if it's already protected in the Constitution? Article 35 of the Constitution says we have a right to access information. I'll use the terms interchangeably, but it means the same thing. Freedom of information and access to information kind of means the same thing. So the constitutional guarantee is there, but we need a framework that talks about how it's going to be done, who has responsibilities, what are legitimate exemptions to this right, what are legitimate limitations. As it is now, if you try and agitate for this right and you get a refusal, then the court, you have to go into courts, and people are using the wrong kind of refusals to say, well, no, we can't give this information, it's sensitive. And that's not a justifiable limitation of your right. And so those are some of the things, important things that a bill needs to address, and that's why we need this framework as soon as possible. So I'd just like you to take 1 minute to tell the person next to you how internet and freedom of information are related. 1 minute. If you go to church, you're used to doing this. What is the link between freedom of information and internet freedom, and the internet? Okay, I'll pick 3 or 4 people at random. Don't tell me what you said, tell me what your neighbor said.
Okay, I think my neighbor said that internet is just like, the newspapers, the TV, the what. And just as you have rights over these other media, internet should have, unlimited rights. And everybody has a responsibility to watch over what they want to see and what they don't want to see.
Thank you, that's a very good contribution. I think you traveled very far to come all the way here, you should say something.
Yes, my neighbors and myself, we talk together, so talking about the fact that information, but if it's digital, they are more accessible, or it could be more accessible. It also decentralizes information from one point to several points. It also talks about the fact that some information needs to be protected, like personal, financial information, that kind of information.
So you just covered both our presentations, but we'll go ahead with them anyway. Thank you.
Okay, my neighbor said the internet is a platform where everyone is allowed to share information, what they think, and therefore, being a platform where there's freedom to share information, it's a risk and it's a threat if it's shut down.
Thank you. Did anyone say anything about, I think you're alluding to that, about censorship, and I think also Honorable Demo alluded to that in other countries. Did anyone talk about that? No, okay, I get to talk about that now. So generally, like you all say, the internet is a medium, a very powerful tool for information, as you all know. And so because the right to freedom of information talks about the right to seek or impart, receive ideas, then it's very relevant to this context. I'm personally not a techie, and so most of the things that you've been talking about have been going like that. But certainly the medium in itself is very important to this right. So I would really encourage you to engage with this bill in the wider stakeholder process, and just to engage with what's going on, because without this, then it will also affect, this sector and of course the wider community of Kenyans. In fact, the UN Human Rights Council have passed yesterday, I think it was, the first landmark resolution that internet freedoms and access to internet should be guaranteed and promoted to the same extent and commitment as human rights in the physical world. So, if you're looking for impetus, there it is. Okay, so as I was thinking about this presentation, and I thought, I can talk about this bill, but how will I make it relevant to this audience? And so I was thinking about what are some of the examples of things that can be incorporated into a bill to maximize the power of the internet. And perhaps in the plenary you can throw up some of those suggestions. One of the things that is not provided for in this bill, that perhaps as Kenya IGF or as some sort of coalition that can be pushed for, is a requirement for ministries and public authorities to provide data in usable forms that you were just talking about. That would make information searchable, it would make it identifiable, and it would make it useful. There's no point if we have open data and you go and get a bunch of PDFs or a bunch of other kind of formats that are so difficult to use that we're not harnessing the power of the internet and of social media. I mean, social media is about getting information there in easy forms, quick forms, accessible forms, easy to duplicate and send out, and things like that. So that's one of the things that we can agitate for in this bill. It doesn't exist in many other bills. There's one in the States that's not even an FOI bill. It's a legislative bill, but has a minimum requirement that the format must be electronic, the format must be searchable, it must be identifiable. And that's a progressive way to do things. If we're going to be moving, we can't just be looking at infrastructure, we can't be looking at technology alone. If when it's all said and done, then we can't even move this information around. So these arguments need to go together. As we're doing the work on the infrastructure and technology, we also do put responsibility on the governments to collect information and provide it in certain formats. So as you all know, format and usability are so important when we're thinking about the internet. So that's just one suggestion to get you thinking. Then we'd like to hear your brilliant suggestions when we come to the plenary. So concerns of the bill. I'm just going to give a very brief overview. We've done a more in-depth legal analysis of this bill. It's on our website if you'd like to access it. So we're just going to try and give you a run through so that you have a general idea of what's in the bill and what the main concerns are. So firstly, of course, the right to access to information. That's well articulated in the bill. Who should have the right? There's some argument about whether the right should be limited to citizens or to everyone. And it has stayed as citizens because that's what the Constitution provides. But some people are arguing that that's unconstitutional if you read it together with other sections of the Constitution. Second, the commencement of the bill. It's a small issue, but it's a big issue. It gives the power to a minister to, yes, the bill can be enacted, but when it actually commences, it's up to a minister, which is putting power in the hands, of the government, which it shouldn't have, because this is a legislation actualizing a Bill of Rights provision, which automatically came into force when the Constitution came into force. And so we think that should be revised, and we just set a date and say within 30 days or whatever else. It should not be at the discretion of a person when we get to enjoy the benefits of this legislation. There's a section of exemptions. I talked about exemptions to the right. They're actually legitimate exemptions. There are times that you can be told, no, you can't have this information. And those are national security concerns or things like that. And we have a list, if you look through analysis, of what legitimate exemptions are. Generally, the new revised bill covers the exemptions a bit better, but we think there should be a burden on the public authority, a provision saying they must grant a request for access to that information requested, unless you can demonstrate that there's a substantial harm to a very legitimate interest if we give out this information. But the burden of proof is on them. It's not up to the requester, it's not up to anyone else, but they have to be able to demonstrate. That gives more accountability, that forces them to provide reasons. And it just kind of prevents them just saying, the public authority saying no to information requests. Also, something missing from the bill, which is an area of concern, is something that is called the Severance Principle. Now, you might have information that's in bulk, for example, can be exempted as a national security concern, and we understand that, and we say yes, okay. But there are parts of that information that are not relevant to national security. They just happen to be contained in the same bulk. We should be able to sever that information and leave whatever is pertinent to national security. So we believe that the severance principle is very important, otherwise national security or other legitimate exemptions will be used in a blanket form and will carry a lot of information with them. So to protect freedom of information, that's an important principle. The procedure for accessing information as is in the bill, it's comprehensive. It's quite well provided for. They provide for good time provisions in terms of when you put in your request and when you get the information and things like that. The only thing is, I would suggest maybe in the translation, because you can get information either in English and Swahili under this bill. So if it doesn't exist in the language which you requested, they say that they'll provide it within a reasonable time. Now, if you know this kind of hours, a reasonable time could be anything between 1 month and 5 years. So we think that we should put in a provision to say, within 6 weeks, put a time frame so that people then can be more accountable and so that this right can be actualized. The issue of costs, very well provided for, reasonable fee. Freedom of information principles say that you should be able to access information at the lowest cost possible. In fact, it's advised it shouldn't even be more than the photocopying costs. Otherwise, it will be a hindrance to people getting information. So that's a good feature of the bill. Another provision is public information officers. Now, this is a very important part of freedom of information. If you do not have a designated public information officer, it's very difficult to actualize this right. Someone who is trained in freedom of information principles, someone who that's all they do. Right now, our public information officers are communications people and PR people. They won't serve the purpose that we're looking for. So it's very important that we have a requirement for the designation of public information officers. Right now, the bill says, at first instance, the CEO is a public information officer. Now imagine you're going to a public authority to request information, and you have to deal with the CEO whose travel schedule is crazy, who's not in the office, and all of this. It's not practical. It's not. So we're suggesting that to flag up that area of concern and have designated information officers. Now, it is proposed in this bill that the body that covers this is a Freedom of Information and Data Protection Commission. I know Kenyans are tired of many commissions. The argument has come up, do we need a department? Do we need a commission? And the argument for a commission is that you need a sole body, because this right is a facilitative right. It facilitates all the other rights. You need information to agitate for your right to education. You need information to agitate for your right to water. You need to agitate for how are they using my CDF. So being a facilitative right, it needs its standalone body dealing with this, and what they're proposing to call it is the FOI, the Data Protection Commission. So the areas of concern with this commission, the main ones, the independence of the commission. Now, this was redrafted in the 2008 bill. The independence of the commission proposal was quite good. Right now, what they're saying is in order to become a chairperson or a member of the commission, there's going to be a selection panel. There are going to be 6 members of this selection panel. 3 out of the 6 members of the selection panel are government. Office of the President, Office of the Prime Minister, and a ministry, I think it's of justice. So if you have half of the people selecting who's going to be a commissioner in this, and half are the government, then of course they're going to have, certain interests in terms of who's picked. And the independence of the Freedom of Information Commission is so important because of the sensitivity of the issues as well, and the kind of information that people might be wanting to request. And we wouldn't want a commission that allows refusals of information on very flimsy grounds. So we want as independent a commission as possible. And not independent just because it has the name independent in it, but its constitution is actually independent. So our recommendation is that Parliament, with a 2/3 majority, should select this panel. And then the President can do the ceremonial appointment, but it certainly shouldn't be in the hands of the President or have 3 representatives of government making up half of the selection panel. It's the same again with, if you want to remove a commissioner, the National Assembly receive a petition, but they give it to the President. So the President can either order suspension or can say, let's form a tribunal. And it's the President forming the tribunal. So you see, the independence is quite compromised, and those are areas of great concern. Now, the bill also provides for appeal procedure. The way that the appeal procedure works is that whichever public authority aggrieved you, so to speak, must have an internal review system. So if you've gone to KEBS, for example, KEBS will take the refusal through their system, and then they'll give you an answer as to why you were refused. And then you go to the commission, and then you go to the court, if need be. So it's a good appeal procedure. What we're recommending is time limits, just for expediency. Again, there are provisions of reasonable time, things like that. So we're recommending actually put specific days so that we can have more accountability. again, we're requesting a express provision that the burden of proof is on the public authority, not on the requester. Because many times people are saying they're going to request information and they're being told why you have to show why you're allowed to get this information. That shouldn't be the case at all. That's your right. They have to show why they want to limit your right. And there needs to be an express provision saying that. So the last couple of things, measures to promote open government. They're really good measures to promote open government in the bill. They've put within 12 months of commencement of the bill, all public authorities will have to publish certain information, including what facts they use to arrive at certain policies, what they do, and things like that. So that will work to promote open government. Accountability for public authorities, that's also a good provision. There's a requirement for public authorities to submit an annual report to the Commission. It's a good provision, but there are no penalties if you don't provide the report. So that's an area of concern, because the public authority can choose not to do that, and then that provision is useless. So there needs to be some tightening up. The last one, protection of whistleblowers. Now this is a big area, a big component of freedom of information. Whistleblowers are people who disclose information about large-scale violations. So for example, great corruption or some human rights violations or things like that. And the thinking around protection of whistleblowers is if you give people protection against being fired or any sort of reprisal, then they're more likely to bring information that's in the public interest to know and to stop, these high, I suppose, high impact level violations happening. And so it's a jurisprudence that's done. It's done internationally. It's done regionally in some African countries, as well as some East African ones. I think Uganda, although I could be wrong. So this protection is really important, and the bill does provide for this protection. So people that do give information that they obtained maybe in the course of their work, or that they know, about what's happening, then they'll be protected, which is a really good thing in terms of disclosure. Lastly, the government, under Article 35 of the Constitution, has a duty to proactively disclose. That means that I shouldn't have to come and ask all the time for information. You should be proactively giving out information about what you're doing, things that are of interest to certain groups, and things like that. And that's also captured in this bill. So that's a good feature. So that's the bill generally. Just to give you an overview of some of the good and some of the things that need improvement. Sandra will be talking about the data protection bill, which you understand is about private information and not public information. Like I said, a more detailed legal analysis is available on our website, but I just want to encourage this forum. We haven't really had, in the stakeholder reviews, we haven't really had a voice from the IGF community or the techie community, as I call it, and we don't have a lot of expertise in this area. So if a brief or even some sort of one-page statement could come out of this, that could be submitted to the Constitutional Implementation Committee for consideration. The draft has not yet been forwarded to Parliament. They have said that under our Open Government Partnership Plan, that they want these laws in place by November 2012. So this law and the data protection law. So this is just an appeal for your involvement. I hope that you've been able to have an opportunity to see the importance of why you need to get involved. And if you have any questions, please feel free to get in touch. Thank you for your attention.
Thank you, Stephanie. We'll have Sandra presenting. We'll have Sandra presenting, and then we'll take questions about both presentations.
here. I've never had so many acronyms in my life. Seriously, and I work for the NGO sector. Yeah, so thanks, Jeff, for the FYI. I'm going to present an overview of the Data Protection Bill, which is just the other side of the coin from the Freedom of Information Bill. Being that freedom of information and privacy, kind of that connection cannot be avoided. So I don't know how many of you have interacted with the Data Protection Bill at any level. So I decided probably I just have a brief overview, giving you an idea of what is in there. Because I think from what I was hearing, this is very relevant for people in your field. So I'll just have a brief overview and highlight some of the observations we've made so far on the bill. And then from there, you can all just kind of try and see in terms of the linkage, maybe it can come during the plenary session. So the Data Protection Bill is defined as an act of parliament to regulate the collection, the processing, storing, use, and disclosure of information relating to individuals. So this relates to individuals. This is about personal information, and that's why it's about privacy. Stephanie was talking about public information. I'm talking about personal information and how it is collected, how it is processed, how it is stored, how it's used, and the disclosure relating to individuals. Whether automated or manual means and for connected purposes. So that's how they describe the bill. Next slide, please. And this, it's premised on Article 31 of the Constitution, and if you just allow me to highlight that, Article 31 talks about every person has a right to privacy, which includes the right not to have information relating to their family or private affairs unnecessarily required or revealed. So it talks about Article 31 guarantees your right to privacy. So kind of giving back to this bill. And in that bill, privacy in the bill describes a person's right to control what happens to personal information about you. So what level of control do you have of the personal information that is out there about you? And the intention is to establish rules governing collection and handling of your information. So kind of putting in place regulations to see how is, especially in this internet, I guess you're the people who would know best in the internet age. Information is so free-flowing, it moves fast. So when it comes to personal information, what are the rules governing the collection and handling of the data? And that could be credit information, could be medical records, could be government records, electronic commerce, and all that. And so personal information in this act is referred to as personal data. We always have this argument or discussion with Stephanie in the office and other colleagues. What's information and what's data and what's the difference? Maybe you're the people who know better. I don't think we ever come to a consensus on that. But in this act, it's referred to as personal data, which, according to them, is a wider term that covers identification numbers. So that's how data is described. And it's divided into 7 parts. It's not a very long bill. I really would urge all of you to have a look at the bill. I think it's you're one of the I don't know in the stakeholder meeting that we had whether there was somebody from IGF, because CIC has been holding some meetings. And okay, at least there's been one major meeting about this, and but I think probably it would really add something if somebody from here was there. The bill is not very long. It's divided into 7 parts. The first part, as expected, is about interpretations, and they give definitions of quite important aspects like agency. What does agency mean? It's public and private bodies. They define data. They define personal information. They define data controller, and you find all these terms used all over the bill. If I just pick, for instance, definition of personal information according to the bill. So information to be protected is information relating to race, gender, sex, pregnancy, marital status, national, ethnic or social origin, color, sexual orientation. Information relating to education, or medical, criminal, or employment history of the individual. Any identifying number, symbol, or other particular assigned to the individual. Address, fingerprints, blood type of the individual, personal views. So you see, it's, I think it would help if you looked at the bill and how they define some of these things to see what exactly do they mean by personal data. What's your personal data according to the bill? Kind of an observation there. However, the bill also includes some interpretations of words that don't appear inside the bill, like whistleblower, public servant, public record. That's kind of a limitation which we'll look at later. I was just flagging that out. So yeah, as I said, part 1 is about preliminaries. Part 2 is about personal information protection principles. Which principles are observed in the, in terms of applying the bill? So I think in this section, the bill tries to comply with international standards. Because internationally, there are standard principles and standards that need to be observed for you to say that you're applying privacy. And I'll just make a run through. The principles require that personal information is obtained fairly and lawfully. The second principle is that information is only used for the original specified purpose, which, I don't know, in our forums, there's a bit of discussion about this. Like, there was some question about how information is used, especially in the internet age, and how it's shared, and how it just is able to cross boundaries. The third principle is that information is adequate, it's relevant, and not excessive to purpose. Your information should just not be collected for the sake of being collected. It needs to be for a specified purpose. It needs to be accurate and up to date, and accessible to the subject. That means you should be able to access your personal information at any given time that you want to. It's kept secure, and it's destroyed after its purpose is completed. So those are some of the principles the Act tries to observe. And it also deals with the rights of data subject. That's you. You're the data subject, according to the interpretation of the bill. And talks about some of the rights you have as a person who, as a data subject whose personal information is somewhere. It says that you have the right to access that information. You have a right to see what information is there about you. You have a right to know the place of origin of the data. Where did they get that data about you? You have the right to know what they're going to use the data for. Any other person to whom the data is transmitted. That means if you give personal information to a certain, maybe institution, they require your consent for it to be able to be used by somebody else. And there's a lot of contention about this. Like the question, I don't know, some people ask, how do this, like Safaricom or Airtel, or, like the way you get some marketing information on your SMSs. Yeah, there's this promotion, there's this competition, and you wonder, okay, I never subscribed to anything like that, but I seem to be getting all this information. There's a lot of question around that, like, at what level is your consent required for your information to be used? You have a right to rectify incorrect data about you and to erase illegally processed data. So that's some of the rights the bill gives to the individual. And in keeping with these principles, the part therefore also deals with how information is collected. It talks about unlawful collection of information. What is it to say that information was unlawfully collected? It talks about protection of personal information. Correction, what do you need to do to correct your information that's out there? It talks about storage, misuse, and disclosure of information. So that whole part deals with all these aspects I've highlighted. Part 3 deals with the powers and functions of the Freedom of Information Commission. Stephanie has talked about the body that will regulate all this. Now, for data protection, and this is where data protection links to freedom of information, they're saying that the commission created by the FY bill will be the same commission to regulate matters of data protection. There's a lot of discussion about this, like, is it the same thing to say that if I can deal with freedom of information aspect, I can also deal with data protection? Is it necessarily the same qualification or need. Isn't there some kind of a contradiction? So there was a lot of discussion about this, but at the moment as it is in the bill, the commission, the information commission created under the FY bill is the same one mandated to look into data protection. And we'll see some questions that came about because of that. And in the draft bill, in the data protection, so it lays out the mandate of the commission with regard to data protection. So what do they do? The mandate of the commission under data protection is they investigate your complaints, they undertake inspection of agencies, they inform and educate the public about data protection, about freedom of information, they recommend effective measures of data protection, they act as a chief agent in ensuring compliance, they describe and approve data protection codes, and they prescribe damages. So they have quite a bit in terms of powers and, powers to kind of regulate a lot in regard to data protection. I think it's one of the areas where we need to be clear, like, will they have the mandate, will they have the capacity to do both functions? But at the moment as it stands, that commission applies to both freedom of information and data protection. They can even, in fact, we're asking, like, okay, what kind of a commission exactly? Because as you see, they have powers to kind of adjudicate on cases. They can prescribe damages, so it's quite a wide mandate. The fourth part talks about complaints, proceeding, and settlement. How do you go about complaining? In other words, what is the process for you to complain about maybe a certain violation of the principles of data protection? It talks about what exactly do you do, how do you set out complaints orally or in writing, and the actions the commission might take when they receive your complaint. So it's about the practicalities of what you do if you're aggrieved. And clause 21 in that part contains the principles that will guide the commission on settling the complaints. Part 5 talks about the powers and remedies of the commission, and it says that the commission can grant damages, they can also issue restraining orders, and other remedies it may seem fit. The sixth part is miscellaneous provisions, and the seventh talks about offences. If you're found guilty of violating data protection principles, what offences are available? It deals with people who obstruct the commission in exercising their functions, or if you make false statements or give information known to be false or misleading, it's also an offense. It talks about falsely representing your authority. For instance, if you go about saying that you represent a certain organization and you don't, what's the recourse to that? And at the moment, according to the bill, it says a person found guilty is liable to a fine not exceeding 100,000 shillings or imprisonment not exceeding 1 year or both. So there are actually penalties for this. So in a nutshell, that's what the data protection bill talks about. As I said, it's short. It talks about what is personal information, the principles they observe. It talks about this commission and what to do in case you're aggrieved. That's what the data protection bill is right now. I'm just going to highlight some of the observations we've made in the process of deliberating about the bill. So the first observation is data protection rights and freedom of information laws, they are complementary. They are designed to kind of go together. And because on one hand, they empower an individual citizen to protect their rights. On the other hand, there's still supposed to be some sort of transparency of both public and private bodies. So they should be well crafted. They should meet international standards to protect individual rights. And over 70 countries have actually adopted data protection laws. 50 of these also have FY laws. So 50 of them have both FY laws and data protection laws. In Africa, I think we have about eight countries who have data protection laws. That's Angola, Benin, Burkina Faso, Cape Verde, Mauritius, Morocco, Senegal, and Tunisia. And so, I mean, countries are increasingly seeing the importance of data protection laws, especially in the issue of, in the age of internet and all that. One of the limitations the bill had previously, which we are happy, has changed regarding the scope. Initially, the data protection bill only applied to public institutions, so government institutions, I don't know, parastatals, ministries, and all that. But it was since amended to include private institutions, so they cover corporations, non-profit making organizations. And I think this was a good step because I think that's only strengthened the law. If you look at right now, in fact, the trend, I think somebody even mentioned it, European laws are increasingly restricting transfer of information to countries that don't have data protection laws. And it, if you look at the bigger impact of that on international trade, on the whole issue of outsourcing, at some point, all countries will require to have this law if you want to engage in international trade without restriction. So it's good that they widen the scope. The definition there was a recommendation there that exemptions should be made specifically for information held by media, academic, and journalistic activities. That's the whole, when we say that journalists and media and academic people do not necessarily have to, for instance, give the sources of the information and all that. So in as much as we are saying the scope should be widened, we should keep in mind the issue of media, academic, and journalistic activities. The definition of personal information. As I read here, if you remember, the definition covered criminal records information, including that relating to investigations as personal information. As FOI activists, we would of course have some type of issue on this because sometimes it's in the public interest for some information to be out there. And you may call it personal, but for instance, if you're a public figure and maybe there's a certain criminal record about you, or certain, some of the activities are being questioned, to what extent can you really say that is private information and I require privacy for that? So there's the whole issue of how personal information is defined. And for us, we recommend that criminal records should actually not necessarily be defined as private information, because some are public, some people's functions are public in nature. Therefore, it's in the public interest to know. We also talk about the mandate for the Information Commission. I've already mentioned that the bill links to the FOI bill by extending the jurisdiction of the Commission to deal with data protection. However, it's silent on how this is going to be done. You've seen all the functions of the Commission, quite wide, quite involving. But the bill is silent on how will this be done? How will it be funded? Is there money set aside? So the practical applications of this, it's on paper, but practically applied, the Information Commission needs to be facilitated to also undertake data protection, and the bill is silent on this. So when it comes to implementation, it may well be that it's in the bill, but then the Commission is not able to function, maybe both ways. And also because of that linkage you're asking, so are they going to be passed together? Because one bill has kind of extended into the other, so it would seem practically that it should require that the FOI bill and the data protection bill be passed together. That certainly seems to be the intention, because I think the data protection bill is actually a government bill. But in terms of precedent, this has happened in the UK, Germany, Mexico, Thailand. People are taking that route. And I think I've talked about unlinked concepts and definitions, meaning that there are some definitions that are put in the data protection, whistleblower, public record, public servants that are not necessarily in the body. I think there was a bit of copy pasting. That's what I'm actually saying. That needs to be, some more thought needs to be in why some of these terms are used. In terms of where it is at, the status, the data protection bill is with the CIC. If you look at their website, they say that stakeholder analysis is ongoing and people should give their views. I don't know exactly how they intend that this stakeholder. I think it's more like in their thinking, if you're interested, look at the data protection, give your views, either as an individual or organization. recommendations, because we had one stakeholder analysis with them, and from, I think, my colleagues were there and they can correct me, but I think they said they would not have another, roundtable sitting again to review. That said, there were a lot of issues raised that were not ironed out. I don't know what steps they, because we actually went clause by clause. There was a lot of hanging issues, even drafting-wise and somehow conceptually, that we raised. I don't know how that has been dealt with. And I think it's definitely something you as a sector need to look into. So if in fact you got yourselves together, one time in a round table and just decided to look at through the data protection, I think it's something that really touches on, what you people are concerned about. So yeah, just in terms of raising the interest, as my colleague did on data protection laws. So that's what we have in terms of a data protection bill. As she said, they are working hard towards having it by November 2012. So yeah, just my urging that I think look at it as a sector. Thank you.
Thank you. Thank you. Are you guys on Twitter? Because I will only take questions that are 140 characters. In the interest of time. In the interest of time, we take questions that are 140 characters and reply in the same fashion.
My question is both to FYI and data protection bill. What really is the scope of the law considering the internet? If, for example, giving my information to people who are in another country, can I seek redress if they share it out with other people, or is it just restricted to people who do internet activity or any other information they get?
Thank you. Tabi?
Thank you. My name is Ivan Sikwa. My first concern is whether the questions or comments that we direct to you will probably be directed at the right place or not, in terms of you guys have just done analysis and maybe you're not the ones who are going to determine what goes into the bill in terms of recommendations or comments. And having said that, there is I've had the opportunity to go through the bills, both of them, and I think I would say as you pointed out, I think they're quite shallow in terms of the content that they're supposed to cover, and I don't know how they were drafted in the first place, because I would have expected to have seen the drafters of these bills getting out to us in the ICT industry and trying to get views from us before they even come up with this first draft. Because looking at them from my point of view, I see that there's a lot of things that are missing that I think are important. One particular issue that I would like to point out is...
I'm sorry, please let's fix. Because in the interest of time, I have to fix.
Sorry about that. Okay, one particular issue, looking at the Freedom of Information Bill, it deals a lot with access to information held by maybe government or whoever. But you'll find that a lot of government agencies, as we speak, hold data in proprietary formats. Okay? Up to just the other day, if you went to the KRA website to pay your taxes, you'd only be able to access that using one particular proprietary browser, and not everybody uses that, which is Internet Explorer. And they've already changed that, but a lot of other government agencies are holding information, government information that is public information, in proprietary formats that we cannot access because of differences in technologies. A lot of governments in the world, maybe through the Freedom of Information Acts, they require that information be held in internationally acceptable open standards and open formats that everybody can be able to access. I think that is one thing that really needs to be captured in the Freedom of Information Act bill in terms of access to information by the public. And it would also be important for us to know if you've already interacted with the NCAC, whether there are still opportunities for us to be able to interact with them
Sapa, then Shuki.
Thank you. My name is Jane Koo. My concern is that as much as we focus on these bills and most of the information that we seek is from government, I'm just wondering where we also need to also demand as information from even service in the private sector, because whatever they do also has impact on the public. And I'm just giving the example of the information that JetLink, just recently that came out to the public domain. It's offering services to the public, security issues. We've also seen the GlaxoSmithKline holding of important information. So how do we also make sure that anybody dealing or in the sector that affects the public also gives information?
Thank you. My question is with respect to what is going on in various countries who are in the process, especially for us in East African community. In Kenya, we're still in the drafting phase, if I may put it that way. We've seen statements from Rwanda recently, and where they've said that the government has put across a law that data cannot be exported outside the boundaries of Rwanda. Is there any harmonization? Is there any harmonization that's going on between the regional economic communities, that's the East African community, to harmonize our data protection laws? Because as we are moving towards an integrated region, if we don't harmonize, then that means we'll have wasted a lot of time, because we are all in the process of developing. Whether if we don't do it now, then it means we have to redo this process later.
Okay, you'll handle this in about 5 minutes, please.
The first question directed freedom of information was with regards to accessible format and things like that. And I made reference to that in the presentation. That one of the things that this forum can do is provide a brief. Having the experience in this sector and things like that is provide a brief to the NCIC about the benefits of that and just the requirement to have electronic records in formats that are usable and shareable. As far as opportunities to engage with the the CIC, not the NCIC. Sorry. Yes, they say that the bills both bills are under stakeholder review. Like Sandra mentioned, they're not going to be holding any more actual meetings on the data protection. I don't know what their position is on the FOI bill, but as long as the bills are up on their website, you're able to provide a brief and follow on. I think the process is still open until it leaves this year. As far as incorporation of your recommendations at this stage, we obviously can't comment on that. The question on private bodies. The bill makes a provision to access information of private bodies that are either performing a public function, have some sort of public resource that are using. So those kind of public bodies are already targeted under this bill, which is a very good provision because not all freedom of information bills have that. But secondly, the Constitution in Article 35, subsection 35(1)(b) says that you have the right to access information if it's held by another person and you require it for the exercise or protection of any right or fundamental freedom. So that's sort of like an override. If you can demonstrate that you need information from JetLink or any other private organization that doesn't necessarily perform a public function, but you require it for the enforcement of a right, then you can access the information requested.
I think I have two questions relating to data protection. I think I was first asked about personal information outside the boundaries, something like that. Actually, at the moment, there's not much you can do. There are international recognized standards. But that's why there's a push to legislate. As I mentioned before, increasingly, many countries are becoming very reluctant to give information where there are no data protection laws, and that's the reason. So, I mean, the whole issue of legislating is trying to tackle the issue because it's been recognized that not in a practical sense, in as much as the international principles, the international standards, there's a need to do much more. So, yeah. And Mishuki's question, to the best of my knowledge, no, I don't think there's been that consideration of a regional, harmonizing the laws to be regional. Definitely it's an opportunity, but I think our reluctance also as stakeholders has been to what has been raised over there. The standard of the bill is not yet, I think, to a level where we can start, a regional discussion, if you ask me. Yeah, it's a lot still needs to be done, but definitely it's something to consider and it's an opportunity.
I'm so sorry I had to rush you on this very interesting discussion. But I'll kindly ask you that we continue this discussion over lunch. I also have quite a number of issues to raise. Sorry. Seeing as the other day I went to the internet and found that I am a member of another party, not the one I belong to, another political party. And anyone with my ID number can found that information. So it's a very interesting topic. And I kindly ask you that we continue this discussion over lunch. Otherwise, now I hand over to the other Grace. Will take us to the next session.
We had hoped that we'd do the data, the e-government presentation, but the hotel has said we need to have lunch now. Otherwise, we are also going to disorganize. So it's 1:32. Can we please come back by 2:30 so that we are able to catch up? With the other session. We are one session behind. So please, if we can come up, we can come back on time. We will have more interesting sessions. I assure you we have a very interesting session on e-government. We will get to hear from non-formal education in the slum areas and what are their infrastructural issues. We have intermediary liability. So please come back at exactly 2:30. Bon appétit.
Grazie.